SJC-12376, Exxon Mobil Corporation v. Office of the Attorney General.
Mr. Anderson, good morning.
Good morning, Chief Justice, and may it please the Court. My name is Justin Anderson. I represent Exxon Mobil in this appeal, which is not about climate change. We are not asking this Court to weigh in on the causes of climate change, the severity of climate change, what can be done about climate change, whether Exxon Mobil is right or wrong to recognize that climate change is real, to support Paris, and to advocate for a revenue-neutral carbon tax. Those are issues not before this Court.
My understanding is you're here on a jurisdiction question.
Exactly right, Judge, which is the limitation that's placed on the Attorney General's power, which is also not in dispute,
Right.
to conduct investigations.
Well, before you go any further, let me ask you, just in general terms, what would be the harm if Exxon was subject to jurisdiction in Massachusetts? What's the harm to Exxon?
There's two arms. One that's been recognized by the Supreme Court as recently as this summer in the decision in the Bristol-Myers case, is that there's a liberty interest in not being subjected to the jurisdiction of a sovereign where you're either not at home or you haven't established the connections, the substantial connections that would give rise to the claim that's at issue. And then the other issue the other very important interest here has to do with state sovereignty, and this was also in the Bristol-Myers decision, is that personal jurisdiction, as applied by the Due Process Clause, imposes a restraint on what a state sovereign can do to a non-resident. And under both the long-arm statute here in Massachusetts and the Due Process Clause of the federal Constitution, the requirement is that in order to exercise jurisdiction over a non-resident, that non-resident must make purposeful contact in the forum that has a substantial connection with the claims that are issued.
Along those lines, your position is that the Superior Court judge didn't consider Bristol-Myers Squibb, didn't consider Walden as it relates to substantial connection. So as it relates to this nexus issue between the CID and the suit, are we supposed to look at the entire record and apply that doctrine, or should there be a remand for it to be applied? What's your position as to that?
Well, Your Honor, our position is that the Attorney General bore the burden of proof in front of Justice Breyer, and they came in with what they thought was their best evidence in support of asserting personal jurisdiction over ExxonMobil. They pointed to any number of things like a pipeline that we haven't owned since before the CID was issued. They referred to the terminals in Everett and Springfield, one of which we don't own. They referred to the service stations that bear the brand. Justice Breyer heard all of this, and she credited only one of those theories, which was the idea that because there are service stations in Massachusetts that are licensed to use either the Exxon or the Mobil brand, therefore there must somehow be jurisdiction over ExxonMobil for the climate change investigation that the Attorney General is conducting.
Did she, when you say she credited only one, do you mean that was only one that was discussed in her decision, or did she specifically exclude the others in her decision?
The former, Judge. It was the only ground that she referenced in her decision was the existence of the service stations in Massachusetts. And it's undisputed based on the record below that those service stations pay a fee in order to use either the Exxon or Mobil brand. But in terms of the fuel they sell, they bear sole responsibility for sourcing that fuel from wholesalers.
Are we bound by that limitation that you say is in that decision? Or can we look at the other allegations made by the Attorney General that were before the judge?
Judge, you're bound by the facts and the record that were before Justice Breyer. That's entirely correct. But if there are alternate grounds that are supported by that record and by those factual findings, the court may affirm on alternate grounds.
I have one other question, and that is, am I correct that where you would admit you have jurisdiction is Texas?
In Texas?
Yes.
Yes, in Texas.
And New Jersey?
Correct.
Any other states?
Well, any other state, and it could very well be in Massachusetts, if there are in-state contacts
Yeah, I understand.
that give rise to
But
the,
I'm just curious, like, you must have been looking into this and doing this for a while. So where else do you think you're subject to personal jurisdiction?
it would depend on the claim, Justice. I'm not trying to be difficult.
So
For general
it's unique to
jurisdiction,
the specific claim made, you're saying?
So
correct, under Daimler, you have general jurisdiction in your principal place of business and where you're incorporated. So for ExxonMobil, that's New Jersey and Texas, just as you said. But then for personal jurisdiction, it really depends on what claim is being asserted.
What about New York?
I'm sorry?
New York?
It would depend on the,
Well, isn't there a similar case going on in New York? Aren't you providing information to the state of New York based on similar issues that are here?
there is a climate change investigation that's being conducted by the Attorney General there. And that investigation is subject to its own supervision by the court in
Right.
New York.
But I guess the question is, are you admitting that that New York has jurisdiction over ExxonMobil?
Well, we've not contested jurisdiction in those proceedings.
this is
So
a,
you turn the documents over in New York?
We've been working with the Attorney General to produce
And
documents.
is the request similar to the request that this Attorney General has made?
Well, in many ways, they are not similar at all. One of the requests in the CID is for every document that we've provided to the New York Attorney General. Other requests in the CID, and this demonstrates just how far afield this investigation, as documented in the CID, is for Massachusetts, asks for information pertaining to statements that the former CEO made in Beijing, China, in England, that he's made in Texas, that he's made in New York. These are, in the CID, there are a number of statements where the Massachusetts Attorney General is conducting investigation that are utterly unconnected to any activity in Massachusetts.
well, let's press this a little bit. What if, what if the CEO of Exxon in Beijing or in Istanbul had declared that Exxon gasoline gets a 30% better mileage than its competitors? And let's assume that's not true. Does the AG have no authority to invoke a remedy for that for Massachusetts consumers who may have relied upon that in purchasing Exxon gas?
In order to compel ExxonMobil to do anything, the court would need to have jurisdiction over ExxonMobil. So that
I understand
statement-
that. That's my question. My question is, if the claim were not that you have concealed and misled Massachusetts residents with regard to the effect of your gasoline on global warming, but the question was whether or not you had misled them with regard to gasoline mileage, would the AG be unable to have jurisdiction to bring a claim against, or to pursue an investigation against Exxon?
Assuming that we are limited to only those facts, that there's a statement made in China by the executive for Exxon that it gets great mileage and that might be fraudulent, then there's no personal jurisdiction over ExxonMobil in Massachusetts for the statement, unless there's some additional fact that indicates that statement was purposefully transmitted into Massachusetts so that Massachusetts consumers or investors would rely on it. And that's what's utterly lacking here, is that linkage. There's a fundamental mismatch between the grounds that have been asserted both by the Attorney General and the one ground that was found by Justice Breger, between what is happening in Massachusetts, setting aside whether or not what is happening in Massachusetts can even be attributed to ExxonMobil. But the activity that is in Massachusetts needs to give rise to the claims that are issued.
As I read the Attorney General's brief, part of it says that the scope of the claim, it's a CID, which makes it a little unusual because it's a discovery request, but part of it has to do with marketing, and the gas station agreements have a marketing component to it. Their claim is that Exxon's marketing is deceptive because it doesn't take into account climate change. How do you address the whole issue on marketing and whether or not that brings them into personal jurisdiction?
Well, I would rely on this court's decision in the Di Pianti case, where the question was whether franchisees conduct could be attributed to the franchisor. And in that decision, this court recognized that marketing, quality, operational standards are necessarily defined in a franchise agreement. That's how you protect the trademark, and that's what's required by the Lanham Act. And that level of control, supervision, oversight of the trademark owner, that the trademark owner has over those who use the trademark, cannot give rise to an agency relationship. And it's that decision that provides the legal structure for how the relationship between ExxonMobil and the licensees who use the trademark, Exxon and Mobil in Massachusetts, to be evaluated. And then for the fact question, this court's limited to the information that's in the record, which is a declaration from the relevant executive at ExxonMobil that ExxonMobil Corporation does not control the marketing of fuel in Massachusetts, that is within the discretion of
I thought
licensees.
I thought they control the overall brand, they have an ability to sort of monitor all of the overall marketing by the franchise. They can't advertise unless they get Mobil's approval of how it's done, right?
Right, they have essentially veto power, which courts have determined is not sufficient control to establish the day-to-day supervision that's
So
necessary.
that's what, I'm just trying to, it's a 93A case, right? So we need a nexus between the 93A claim and ExxonMobil's activities. So Exxon sells tons of gas here, right?
It does not sell any gas.
Well, Exxon's fuel, the oil that, Exxon's
Counsel,
oil
people
is.
think Exxon sells gas here, don't they, when they pull into an ExxonMobil station that's labeled ExxonMobil?
Your Honor,
They
with,
believe they're buying Exxon gas. It might be additives and random fuel from someplace else, but the citizens of the state believe that that's what they're buying.
they believe that they're buying perhaps, what they believe they're buying is gas that would meet ExxonMobil's standards, and that's certainly true. That would be a fair belief, is that the gas that's sold in the service stations must meet the standards, but
I'm just trying to sort of put together a couple points and tell me if this is not enough. So somehow Exxon, the fuel from Exxon's franchisees, which is provided by Exxon, somehow, I may be overstating this, is done here. Exxon controls the marketing of the fuel, how the fuel is marketed by the franchisors, right? I'm just trying to see if I can get some understanding of, and then there's an issue, a global issue of whether ExxonMobil has been misrepresenting climate, the impact of fuel on climate change. Whether any of that's happened in Massachusetts, I don't know from this record. With that, they can't conduct a CID based on that. I'm just trying to understand. That doesn't provide jurisdiction. If there were intentional misrepresentations in Massachusetts, if someone in Exxon had said one statement, would that provide jurisdiction in combination with the fact that Exxon fuel is sold here and that they control the marketing? I'm just trying to understand what's deficient and what would be sufficient.
I understand the question, Judge, and it's all in the nature of a hypothetical.
Right,
Because the
hypothetical.
facts don't support any of those hypotheticals.
Well, I think we're going to have real trouble believing that Exxon's fuel isn't in Massachusetts. I understand that it's sold by the franchisors, but maybe you're right, but I'm going to be skeptical of that.
I can point you to the record, which is uncontroverted, Judge, that the wholesalers here purchase their fuel, or the retailers here purchase their fuel from wholesalers who aren't necessarily affiliated with ExxonMobil. ExxonMobil disclaims any responsibility to supply the gasoline.
So Exxon, none of the oil that's extracted by Exxon is ending up in the fuel tanks of cars in Massachusetts?
Not under the terms of the BFA, not under terms of these licensees agreement. A licensee can get the gas from any wholesale supplier it wants. Under the contract, ExxonMobil doesn't require them to purchase from the company, and it makes no representations that it even would supply if they wanted to. And, Your Honor, this is in the Section 2 and Section 5 of the brand fee agreement that's in the joint appendix, specifically Section 2C and 5A. And it's also in the declaration of Mr. Dosher, paragraph 4. There is no evidence contradicting this. So this was the record before Justice Brieger.
What about the contracts with the state police?
The contract with the state police, as we understand it, is for motor oil, which is different from fuel. And if there were, so for example, with the hypothetical, just to jump back to that, if there were fraud in connection with that contract, so for example, let's say for the motor oil contract, there was some allegation that there was deception in connection with the negotiation of, and again, hypothetical, the contract with the police for the lubricants. Then and ExxonMobil had purposely availed itself of Massachusetts in connection with those negotiations. Then certainly, in that hypothetical world, assuming all of those facts, there would be personal jurisdiction over the company because it sought out to do business with the state police. It engaged in contract negotiations, and so it can't be heard to complain that it didn't engage in suit-related conduct in the state that gave rise to whatever the nature of the fraud is in connection with those dealings. The problem is you can't then turn around and say, oh, because we have personal jurisdiction over you in connection with that narrow issue about lubricants and the state police, therefore we can justify an investigation about statements that you made about gasoline in Beijing and statements that you made in London about whether global poverty might be more important than mitigating climate change. There's a fundamental mismatch there that violates Supreme Court precedents and precedent of this court that says if you're going to bring a cause of action or conduct an investigation, the thrust of that investigation must substantially relate to the contacts in the forum that give rise to personal jurisdiction.
Before you run out of time, what about, just to change subject matter for a moment, what about investors and securities that are being sold? Information about climate change and statements about climate change could have a significant impact on the market.
That's true, Judge. And Justice Brieger's decision said nothing about investors. There was no basis for personal jurisdiction adopted by the court, referenced by the court in the record.
Said we could look at any facts in the record and look at an alternative rationale. Are those in the record?
There's none that would support personal jurisdiction. In connection with equity, the stock that's held by Fidelity and MassFi and all of the other big investors that are based in Boston, no evidence in the record that any of those shares were purchased directly from ExxonMobil, which is what is required under 93A. 93A requires that the defendant be a party to the transaction. So Fidelity can purchase all of the ExxonMobil it wants from third parties, but personal jurisdiction can be based only on the activities of the defendant, not on the activities of third parties. So that doesn't provide an adequate basis. And no evidence in the record, because there is none, indicates that there were equity purchases directly from ExxonMobil. As for the commercial paper, well, that's a debt instrument that matures within 270 days. And for there to be personal jurisdiction arising from those contacts, there is evidence in the record that there were these short-term loans that were obtained. It would have to matter to those lenders whether the long-term consequences of climate change and the impact on ExxonMobil's business from climate change would have caused them not to engage in those very short-term contracts that are really based on the creditworthiness of the company over the next 9 months. And nothing in logic or in the record would suggest that anyone who purchases ExxonMobil's commercial paper would care about the long-term impacts of climate change on the business model.
Okay, if I can just stick with that. So your position is that even if Exxon made an affirmatively false statement which affected the price of its stock considerably, and that Massachusetts investors purchased stock in reliance upon that statement and were injured, there would be no remedy under 93A?
Under 93A. Under federal securities laws, that would be a different standard.
But you're saying that the AG would have no jurisdiction to investigate you for that?
Under 93A, the case is Reisman, and it just requires that under 93A that a defendant be a party to a transaction, whether it's consummated or not. Okay. The defendant needs to be a party. It can't be based on the third party purchases and sales of the issuer stock.
So the Secretary of State may have jurisdiction with regard to state securities laws, but not the AG?
Correct, Judge. And that is the narrow question here. It's not whether there is no remedy, whether there's no ability to bring a suit, conduct an investigation. It's about whether this CID is permissible based on the contacts with the forum that are in the record before the court.
And going back to the other argument with regard to your, those who sell what is called Exxon gasoline, is it your position, going back to my earlier hypo, that if there had been advertising by Exxon that its gas gets 30% more mileage than its competitors, and that was false, is it your view that Massachusetts would have, the AG would have no ability to investigate that under 93A because the individuals who sell Exxon gasoline are not your agents or employees?
Well, it would be a fact question, Judge. If, for example, under that scenario, ExxonMobil had targeted Massachusetts residents with advertising containing those false representations, and in that way purposely availed itself of doing business in Massachusetts, and the investigation related to specifically the representations made in those communications, well, then there very well could be personal jurisdiction.
What if it were
over the
national
company.
advertising?
National advertising that's available to all and not targeting anyone in particular in the state has been held repeatedly not to provide jurisdiction.
Even if it's, so if one watches NFL football and on NBC or CBS, one sees advertising that's seen throughout the nation, that Exxon gasoline gets 30% more mileage, the AG would not be able to investigate that because that's being seen by the entire nation as well as by the residents of Massachusetts?
That standing alone without more would not be enough, and I'd refer the court again to the Bristol-Myers decision. Bristol-Myers had a nationwide advertising program for the drug at issue there. I think it was Plavix, and the court rejected that, and there were other grounds too, like employees
Right,
in
but
the state.
Bristol-Myers permitted the California residents to pursue that action. They just did not permit non-California residents to pursue that action. And the AG is here to protect the residents of Massachusetts.
Well, that's right, because those plaintiffs had actually purchased, used, been prescribed the drug in California, and it was from those events. Those events is what gave rise to personal jurisdiction. The advertising standing alone did not. It didn't work for the in-state.
So you're saying that the fact that Massachusetts residents may have gone to your 300 Exxon stations in Massachusetts and purchased gasoline in reliance on national advertising, which was false, would not permit the Attorney General to be able to pursue a CID to investigate whether or not indeed was an unfair and deceptive practice.
Well, that's an expansion of the hypothetical, Judge.
Which part of it is problematic for you?
Well, now we're linking it to purchases and sales of product in the state.
Well, it's not in dispute that you have there are 300 gas stations which bear the Exxon sign, correct?
Correct, Judge.
So, okay, so I'm confused as to what part of it you say is problematic. I am saying, under my hypo, that Massachusetts residents have purchased gasoline from your distributors in Massachusetts based on what was advertising seen by everyone in the country. And my question is, would the Attorney General be able to do a CID to investigate the extent to which those people in Massachusetts who purchased gasoline from one of those 300 stations had been the victims of an unfair and deceptive practice?
It would depend on whether the advertising that was at issue was purposefully directed by ExxonMobil at Massachusetts consumers. If the advertising is what is forming the basis for the personal jurisdiction. If it's the purchases and sales, or if it's the purchase of fuel in Massachusetts from the licensees, the court would then have to determine whether the conduct of the licensees can be attributed to ExxonMobil. And under this court's decision in DiPiante and Theos against the Mack Truck Company, you cannot just say because a licensee is using the trademark of a corporation that therefore what the licensee does in the state is conduct that's attributable to the corporation.
This is conduct being done, though, by Exxon. It is Exxon who's purchasing the advertising on behalf of its gas stations throughout the country. So you're saying that in terms of purposeful availment, it has to say we want this to be in Massachusetts. It's not enough to say we want this to be national?
For advertising, that's just, yes, that's correct, Judge. Nationwide advertising.
So then nobody in the country would be able to bring an action because you can say, we're not purposely availing ourselves in Missouri or Illinois. This is national advertising. It's not being targeted to any single state.
You could bring an action in Texas or New Jersey. That's exactly what the Supreme Court said in Bristol
Only in the
Myers.
places you're domiciled. And the other AGs would be unable to protect their residents if the AG of Texas and New Jersey chose not to.
Well, they could bring first of all, they could bring civil suits in those states if they chose to. They could, that is a possibility.
So let me follow it one step further, okay? So let's imagine a hypothetical, which may be what the AG contends, is that Exxon has pursued a national strategy, including through think tanks and others, to communicate to the entire nation that gasoline is not a cause of global warming. You would put that in the same example of that since it's not being purposely targeted to Massachusetts, but to the entire nation as a whole, that there's no ability of any attorney general except those in New Jersey and Texas to be able to claim an unfair or deceptive practice.
If they could link it to in-state contact is what's required. So there would have to be some contact with the state. It can't simply be the case that the Attorney General looks across the United States and identifies speech about climate change that she does not like, groups that take a position on climate change that she does not approve of, and therefore issues subpoenas to individuals and entities that have no contact with the state so that they can be dragged to Massachusetts to answer to her because of her disagreement. That is what due process requires. It's what personal jurisdiction requires here, is that if non-residents are going to be held to account in Massachusetts, they can only be held to account here for what they've done here. They have to do something in the state, directly target the state, and then they can be held to account in the state.
What
But
about
if-
the Massachusetts franchisees?
Well, they could be, that's an excellent question. They very well could be and are subject to the jurisdiction of the Massachusetts Attorney General. If this case.
No. I mean, what if the Massachusetts franchisees have been adversely affected by the statements made or the fraudulent actions of Exxon? So they have been induced to enter into contracts with Exxon based on false representations. Can the AG protect the franchisees?
Yes, Judge, and that you see a lot in the precedent here is where an out-of-state, non-resident corporation comes into the state to do business with a Massachusetts resident, and based on doing business, having meetings, negotiating contracts, there's some dispute about the nature of the contract, performance under the contract, or maybe fraudulent inducement into the contract. And there, the non-resident can't be heard to complain about having to answer in Massachusetts court because it chose to do business in the state by seeking out, in this case, the licensees. And if there is fraudulent conduct in connection with that, it's certainly appropriate and
So certainly the
for there to be
AG
personal
can,
jurisdiction.
the AG can pursue that route at least.
Your Honor, if there was any basis for it, we would assume that would be before the court now. But the record is that what the Attorney General is doing is conducting investigation about climate change. In the CID, it lists out plainly what the statements are that the Attorney General thinks might be fraudulent. They pertain to speech that occurred in China, England, Texas, New York, what we said in our SEC filings, none of it.
But they're investigating. Can they, I understand your point that, okay, there's no misrepresentation directly in Massachusetts, but can they, so they know you've made these statements in Beijing and maybe other places, can they conduct an investigation to see whether you've done that here, that any of your salespeople go to Fidelity and make representations? Don't worry about climate change. We're not going to have any, what do you call it, when the fuel is sort of exiled fuel or whatever the term is.
It was us, the stranded assets.
Yeah, I mean, can they investigate to see whether you're doing the same type of stuff here? Because they don't know everything you're doing. They're just beginning their investigation.
Absolutely, and we don't,
But that's my question. So they know you've made questionable comments elsewhere. They know you're a nationwide company. They know you at least do national advertising. They know your stock is purchased by Massachusetts citizens, not directly from you. But can they undertake an investigation to see whether you're making misrepresentations in Massachusetts?
of course,
Comparable?
of course, they could conduct
isn't that what-
interviews of mass.
But isn't that what the CID is trying to do?
Well, if it's trying to do it in an impermissible way. What the Attorney General could do is issue CIDs or have voluntary interviews with Fidelity and all of the other money managers in Boston and determine whether there were any misrepresentations that were made, and then if so, build from there. If they
So
all,
they
they could
can't
also,
start with you, though. They have to,
they,
because,
they can't start with us because they don't have personal jurisdiction over us. They have personal jurisdiction over Fidelity. Fidelity is a resident here. They have personal jurisdiction over the service stations. What they need to establish is that we've done something
so
in
they
the
could
state.
bring suit against all your franchisors to find out whether you've ever communicated anything to them. They could do that?
Well, they could issue CIDs. They could issue CIDs to Massachusetts residents. They could ask for voluntarily for information to be turned over. That's how investigations proceed. You build up. Here, there's been no evidence in the record, and I don't know if it's for want of trying or for want of success after having tried, that establishes that ExxonMobil has made any statements to anyone in the Commonwealth that pertain to the subject matter of the CID.
I have another question. It's a little bit tangential, but can you tell me when did Exxon implement this business model?
Your Honor, I'm not sure. I can provide the court with a letter explaining when.
And can you also tell me whether, I know that the request may be different, that New York State may have requested different things than the Massachusetts Attorney General has, but is there anything preventing New York State from giving Massachusetts the information it has obtained to this point from ExxonMobil?
In terms of any legal requirement that they not provide the
Is there
information?
any non-disclosure agreement going on, or is there
We have,
anything prohibiting them from just saying here?
we have an agreement with the Attorney General of New York.
Okay.
So your answer to Justice Kafka confused me when you mentioned Fidelity, because if there were communications that were intended to be communicated to potential investors, including Fidelity, I thought you said that would not be sufficient unless you were selling the securities yourself.
Two responses. First, they can ask questions of Fidelity because Fidelity is within their personal jurisdiction. The answers they get might not support personal jurisdiction against ExxonMobil.
Okay, but if Fidelity said, we received information from Exxon that we relied upon and was misled by, you're saying there would still be no jurisdiction to investigate Exxon for them because they're selling stock that it's not an initial public offering?
Correct. Under 93A, there would be no basis. Under other statutes, there might be.
So we're back to the securities laws jurisdiction as opposed to 93A jurisdiction.
Correct. And if Fidelity said, oh, no, wait a second, I actually purchased stock directly from ExxonMobil 2 years ago, and they told me lies in connection with it, well, then they would have something that would be quite powerful for personal jurisdiction.
And your view with regard to purposeful availment is purpose for availment means that it is insufficient if you intend your communication to be heard throughout the nation, that you have to specifically intend it to be heard in a particular state?
That's right. If we're just talking about advertising, it's well established that nationwide advertising that might be heard in Massachusetts, that might be heard in California, that might be heard in Maryland, that's not enough. It has to be targeted at the jurisdiction. And again, the Supreme Court just held that this summer in Bristol-Myers, that nationwide advertising is not enough.
Your brother may have a different view of Bristol-Myers in that regard, but we'll hear from him in a moment. Thank you.
All right, thank you. Thank you all.
Mr. Johnston, good morning.
Thank you very much. Richard Johnston, appearing for the Attorney General. Exxon asks you essentially to suspend common sense and your own cognizance of what's going on in this Commonwealth. The Attorney General is not looking to expand personal jurisdiction beyond what this court has already determined in Good Hope, Tatro, and Bulldog. Rather, the Attorney General asks you to look at the facts of this matter and determine that Exxon has deliberately and organizationally and consistently done business here in Massachusetts, which is directly related to the CID topics.
So bottom line is you say that the nature of the franchise agreements does not insulate them.
Among other, it does not insulate them because of the nature of the franchise agreements.
That's my question.
And I'd ask you to
Why?
take a look at a couple of things in the franchise agreement. Number one is, as Judge Brieger found, Exxon does control ultimately the marketing and advertising of the franchisees under Section 15 of the franchise agreement. Another thing I would direct you to is the first whereas clause in the franchise agreement refers to the customers of the franchise gas stations as its, i.e. Exxon's customers. If you look at the website of Exxon, Exxon refers to the gas stations as our gas stations. So Exxon really wants...
How are the gas stations involved in deception or fraud related to climate change?
How do they?
Yeah.
Because, Your Honor, the gas which is sold at those gas stations is among the premier contributors to global warming.
But it's decision-making. So as I understand, the suit-related conduct, which is what we're really trying to grasp, is a 93A investigation regarding deception or fraud involving climate change, correct?
That's right.
How would you define suit-related conduct?
Well, remember, it's not suit-related, it's CID-related.
Well, okay, CID-related in this
But
case.
it's CID-related. We have asked for information that relates to the marketing of fossil fuels in Massachusetts, including advertisements in particular.
So I own Joe's gas station on the corner, right? I'm a franchisee, and you're telling me that I have information that relates to how Exxon Mobil, this ginormous corporation, has marketed and lied about climate change?
No, we're not targeting the franchisees.
I know, but
We're targeting
you're
Exxon.
using them for personal jurisdiction.
We're using the fact that Exxon is more than just a vacant or distant franchisor in this situation. Exxon controls the marketing of those stations. Exxon advertises those stations as its gas stations selling to its customers. As a consequence, Exxon has done adequate business. There's sufficient nexus to what Exxon is doing with those franchisees so that Exxon is, for all purposes, or for these purposes, doing business in Massachusetts.
But it's not their, I mean, their advertising is going to be gas for $2.69 a gallon. It's really the global advertising that's at issue, isn't it? I mean, I'm trying to, the same question Justice Gaziano is asking, I'm struggling with too. It's a 93A case, it's a misrepresentation or unfair deceptive acts case. And, and do you need unfair or deceptive acts by Mobil in Massachusetts? And do you have any besides this national or international stuff? Do you need, because the franchisors seem to be selling gas and putting up ads saying we've got Mobil gas at $2.69. They're not doing the climate change advertising, are they?
Well, part of the problem, Your Honor, that we're looking at is that Exxon didn't do climate change advising with respect to the sale of its gas. The problem we're looking into is, did Exxon know, going back into the 1980s, that its fossil fuel products were among the biggest contributors to expected global warming? And in fact, did Exxon know that the only way to really reduce global warming would be to have a substantial decrease in the amount of fossil fuels being consumed in the world? And knowing all of that, did Exxon hide or fail to disclose to consumers and ultimately investors as well what it knew about what its products were going to do to the environment and what possibly...
Do you agree with your brother that national advertising, if all you have is national advertising, is that enough for personal jurisdiction in Massachusetts?
Well, remember, Your Honor, there's a lot more than just that, but
Well,
let me take that in and of itself.
or stuff in China and London too, that where somebody affirmatively is making some kind of misrepresentation in London and China. Do you need something in Massachusetts that indicates they're making affirmative misrepresentations here?
What we need in Massachusetts, Your Honor, is that they do marketing and advertising and sales in Massachusetts, which they do.
Even
They-
if it just says $2.69 a gallon?
But they do more than that. They do such things as telling people on the radio that they can go out and buy their products here in Massachusetts and tell them exactly where in Massachusetts they can do it. They're going on their website telling people.
That's not misleading, is it?
Well, let me get to that.
Okay.
They're going on their website and telling people exactly where they can find their product in Massachusetts. They're going on into press releases telling people that they are partnering with the Massachusetts State Police to develop an environmentally friendly motor oil. And so they have done all those things in Massachusetts, which constitute direct activities in Massachusetts. And as I've said, they also have advertised to to the world, basically, that it's their stations selling to their customers.
You still need the nexus to the CID, though.
But the nexus is this. If they're doing sales and marketing in Massachusetts, and they know things that they should be telling people, either consumers or investors, that would be relevant to the consumer or investors' decisions, then they've got to make that part of their advertising. They can't simply go around and say, we're selling you this terrific product, and keep to themselves what they know about the possible impacts of those products on global warming.
Well, they absolutely cannot do that. The question is whether they can be sued in Massachusetts for not doing that. They cannot do that.
No, they cannot do that.
The
And
question is not whether they can do it or not. The question is whether or not there's personal jurisdiction in Massachusetts if they do that. It's not whether they can do it, they can't.
they can't do that. And by virtue of the fact that they are selling in Massachusetts and advertising in Massachusetts, that's what makes it imperative that they cannot do that.
But do what? I mean, the franchisor has to put on its gas station, you're creating global warming by buying my gas. I'm just trying, I'm just trying to, the little guy seems to be separate from Exxon Mobil.
There's no question that the little guy is separate. And I think what Mobil is trying, and Exxon Mobil is trying to do, is to get you all to focus on the franchisor, who is not, the franchisee, I mean, who's not the problem here. Exxon is the problem. Exxon carries out its business in Massachusetts through these franchisees, who it controls in substantial ways in terms of advertising and certain other things.
Counsel, before the Bristol-Myers case, there was Burger King, the Burger King case, and the idea of purposefully avoiding jurisdiction through a business strategy, as well as the idea of fair play and substantial justice. Do you think that that's, in terms of meaning that Exxon would have to remove itself from Massachusetts so much so that exercising jurisdiction over it would offend traditional notions of fair play and substantial justice? Do you think that's still a viable doctrine after that, after Bristol-Myers and the cases since Burger King?
I do, Your Honor. And I mean, there have been a couple of questions here this afternoon that have been directed toward Exxon about when it was, in fact, I think it was your question about when it was that it changed its business model. And you will see that a bunch of the answers that Exxon gave during the course of the case are that, oh, in the last few years, we've changed our model substantially. Although it hasn't changed substantially, because it is still Exxon products which are being distributed through Exxon distributors and sold by Exxon franchisees through a message that is communicated to the world as Exxon. I mean, if Your Honors were to go on the website and try to find out where an Exxon station was when you were driving down to Fall River, say, that's Exxon's website. It tells you that you can find a station down in Fall River. You go down to that station, there's a sign on the highway that's Exxon's design sign. You get to the gas station, it has the same Exxon design sign there. What do? You pay there with an Exxon credit card, which has been issued by Exxon.
Now tie that to fraud or deception in 93A.
Because that demonstrates, Your Honor, that Exxon is doing the marketing and the sales in Massachusetts. having done the sales and marketing in Massachusetts, it is obliged to follow Chapter 93A and not engage in unfair and deceptive marketing. And part of what Chapter 93A says is not only must you avoid false and misleading statements, you must avoid failing to disclose things which, if the consumer had known, may have affected the consumer's decision.
So using the franchisers, because we were just talking about that, what is deceptive about what's going on in the franchise, in the gas stations here? What are you hoping to discover through this CID about that? Because you're really talking about what happened in these high-level executive offices, aren't you? You're not talking about what's happening here.
Right. It is not our suggestion that the local franchisee is sitting around spending a lot of time thinking about global warming.
They're not.
That's the sort of stuff which Exxon scientists studied in tremendous...
But what is your CID going to turn up in Massachusetts or does it need to turn up nothing? Can you do this and find nothing in Massachusetts and still have jurisdiction? I'm trying to understand where it's going.
What we do, Your Honor, is we get jurisdiction by virtue of the fact that Exxon has a presence here. Then, after we have the jurisdiction, we undertake the investigation through the CID. We find out what is it that Exxon knew all along from its own scientists about what the impact of its fossil fuel products would be on global warming.
So if they're selling and advertising in a completely innocuous way here, but there is a misleading campaign going on in national advertising and in the offices in Texas and New Jersey, there's jurisdiction here, even if nothing misleading besides the national advertising happens here.
Well, let me respond to that in two ways. The misleading stuff is understood best among the higher levels of the company. But because of and the company is then doing national type advertising, which makes its way to Massachusetts. But the company, Exxon, also, as you see from the franchise agreement, has control over the local advertising. So Exxon has an obligation, and all of this is assuming that what we think may have happened did happen, and there was an understanding about the impact on climate change, that Exxon would have a responsibility both at the national level and at the local level to implement information to the consumers so that they could understand when they purchase a tank of gas that this is going to have an impact on global warming, and maybe they should be thinking about buying a more fuel-efficient car, maybe they should be thinking about public transportation, maybe they should be thinking
Local
about...
advertising, that would give you part of jurisdiction, because I take what counsel said about national advertising not being enough, but the local advertising would be whatever billboards, the Pegasus or the Tiger they put up to advertise their brand, correct?
That's part of it. But if Exxon, I mean, part of what may come out of all of this is that Exxon had a fundamental understanding of what its products were going to do with respect to global warming, which would have obligated them to make statements not only nationally, but to the local consumer who was buying at the local pump. That isn't something that we would necessarily expect the local franchisees to be responsible for at each of their 300 stations. Rather, it would be something that Exxon would implement through its control over advertising for those 300 stations.
If I'm a local franchisee, am I paying any portion of my gross revenue to Exxon?
It is my understanding that you do. Every month, the franchise agreement provides for something called a brand fee, so that's what they're paying to Exxon.
And is that a percentage of sales, or is that a fixed amount?
I frankly don't know.
And is there obligation to purchase the additive directly from Exxon?
My understanding is that they are obligated to purchase Exxon additive. They may be buying that through Exxon distributors or Exxon affiliates. But ultimately, it's Exxon product, as I understand it.
All right. Now, is it enough? I mean, I'm trying to understand what your best-case scenario is. The best-case scenario, if you're permitted to pursue this, is that you will discover that Exxon has been engaged in a practice of concealing and misleading the public with regard to the effects of gasoline on overall global warming, and that, in your view, that would affect the decisions of Massachusetts consumers in terms of the types of cars they purchase and whether or not they are going to be driving or using public transit. Is that your best case scenario?
Well, that is, Your Honor, what we're looking into through the CID in terms of consumers. We're, of course, also looking at whether Exxon failed to disclose to investors what the impact of global warming and attempts to regulate global warming would have on its business, on its assets, and on its valuation.
Now,
And
your brother says you can't do that unless we are directly selling to consumers. It's not enough that people are trading in Exxon stock. We need to focus only on the extent to which they're misled in their purchase of Exxon stocks, and we haven't done any initial public offerings for a long time.
That's respectfully a misstatement of Chapter 93A law. Chapter 93A covers not only sales, but marketing of securities. It does not require a primary sale. It can be in the secondary market as well. And even the issuance of something like a financial statement under the Reisman case can constitute an unfair practice even without a sale. So I think
And which cases have been prosecuted on that theory? Do we have any case law with regard to that?
Well, if you take a look at the Reisman case, was a private party sale, a private party suit against an accountant who had issued on behalf of a public company or behalf of a company a certified financial statement. And the court determined there that there was an ability to pursue a Chapter 93A claim, even though it had not involved a sale of security, and even though there was not necessarily privity between the issuer of the financial statement and the investor.
So you're saying that if Massachusetts investors in their sale of Exxon stock on the market, wholly apart from the sales of their commercial paper, are misled either as to the amount of assets that Exxon has, that's a 93A violation and not merely a securities violation?
It can be a Chapter 93A violation, yes. Securities laws do not preempt Chapter 93A when it comes to unfair statements made to investors.
And must those statements be made in Massachusetts or simply communicated to persons in Massachusetts?
If they are communicated to persons in Massachusetts, that suffices.
And is there anything in the AG regs which speak to this?
The AG regs speak to the fact that a failure to make a full disclosure of relevant and material information to someone can be a Chapter 93A violation, and the statute itself applies to both investors and to consumers. So between the statute, which applies to investors, and the 93A regulation, which we have issued, that protects against the failure to make full and adequate disclosures, gets us to that point.
If I could just follow up on that point as it relates to the record we're dealing with and the analysis that we have from the Superior Court. We're trying to understand whether or not there's a substantial connection between Exxon's activities in Massachusetts and the subject matter of the CID. And it seems like we've got this big record, and there wasn't really a lot of analysis of that in the Superior Court. We've talked a lot about the nature of the franchise agreement with the 300-plus stations. What do we do with that record as we're trying to deal with personal jurisdiction? Or should there be a remand?
Well, as you know, Your Honor, you look at personal jurisdiction on a de novo basis. Mm-hmm. So you may review the entire record, including pieces that Judge Brieger relied on specifically, including Section 15 of the franchise agreement, which is what led her to conclude that Exxon had a specific connection to Massachusetts on the very topic that was the center of the CID. But you can also look at all the other things which I've mentioned today and all the things which we've indicated in our brief Exxon has done in Massachusetts. I think you also can apply your own common sense as to the extent to which Exxon is a player here in Massachusetts. This is not a situation.
And I think we understand that part. What's the best, in this record, because I haven't read the whole record yet by any means, what is the closest nexus of a misrepresentation in Massachusetts? Is there, I understand completely the activities and the extent of those activities, but what would you point us to as what triggered the sort of Massachusetts misrepresentation? Is it some ad that Mobil put on? Is it the speech in China? What is the sort of, in our record, the closest nexus of misrepresentation to Massachusetts?
I'll try to address that in a couple of different ways. One is that the theory of the CID is that Exxon didn't disclose enough. So
it's an
it's
omission.
not Exxon can't answer, as it tries to answer in its
So it's
papers
an
here.
omission in
Yes,
Massachusetts.
it's an omission.
But I thought they're going to, when we read his briefs, we're going to find statements that omission is not enough for personal jurisdiction. You need commission.
They have said that in their brief, but I think they misapprehend. If someone simply doesn't do something, maybe they can argue that that's a basis for not having jurisdiction in the state. But where you affirmatively advertise and affirmatively sell in Massachusetts, and the statute, Chapter 93A, requires that you be full and forthcoming about what you're selling and what you're marketing,
I know.
then if you
It would just
omit,
help me just to point, is there anything in the record that we should start with? Is it the police, contract about clean fuel? What is the misrepresentation? Is there something in Massachusetts that we can start to focus?
it would be the failure to disclose the connections between fossil fuels and global warming on the consumer side. On the investor side, it would be the continuing claims.
So there's not going to be a date or a piece of advertising that was put on Channel 5 or Channel 4 or in the Globe or some editorial written by someone from Exxon. There's nothing like that we're going to find. We're going to have to do the big picture commission omission analysis.
There's nothing in the record that indicates a specific advertisement to consumers. Our issue is they advertise to consumers. We should be able to find out whether they knew a lot about the impact of fossil fuels on global warming, so that they should have said more in those advertisements. On the investor side, we do have things in the record which indicate as recently as 2014 that Exxon was saying in a managing the risk document that there was no risk that any of their so-called assets, which means their reserves, would become stranded.
And is there any connection of that statement to Massachusetts, or is that, where does that no stranding language appear?
It appears in a document that was an Exxon document from 2014, which is our understanding went to Exxon shareholders. And that document said, notwithstanding all the talk about what's going on in the world with global warming and the like,
So that was sent to shareholders in Massachusetts? Do we know whether that document was sent to shareholders in Massachusetts?
Our understanding is that that would have been the case because two of Exxon's largest 10 shareholders in the world are located in Massachusetts. We would expect that such documents would make their way to these large institutional investors, which of course make investment decisions on behalf of hundreds of thousands of smaller shareholders based on what they learn from the company. In any event, the document I'm referring to talks about how none of those assets would be stranded, and in fact, by the end of 2016, Exxon was saying we may have to strand those assets in Alberta to the tune of about $4 billion, and then in early 2017, they did exactly that. And the announcement in and of itself that they were perhaps going to have to write down those assets led to a shareholder suit in Texas, which is still pending. So those are the sorts of connections. There are, on both sides of the equation, what is at stake is what did Exxon know, what should Exxon have been telling consumers, what should Exxon have been telling investors. Those consumers exist in Massachusetts and buy gas at Exxon stations every day of the week. Those investors sit in Massachusetts in the guise of two of the largest institutional holders in the world. They make decisions every day based on what it is that Exxon is telling them.
Now, you've confused me by your answer to Justice Kafker, because I had thought I had read, I think in your brief, that you had analogized this to the tobacco case, that is, that much as the tobacco companies had attempted to debunk the research about the effect of smoking on health and had caused consumers of cigarettes to be misled as to the health effects, that so too has Exxon sought to debunk or confuse or mislead about the scientific literature about the effect of gasoline use on global warming, and that was part of the argument here, or part of your theory. But now you speak only about what they didn't say as opposed to what they did do. So now I'm confused as to what you're saying.
Okay, I didn't mean to confuse you, Your Honor. I think Justice Gaffer was asking me about specific things that were found in advertisements, and I said that with respect to that, what they didn't say is the important part of it, because we conclude and we believe that Exxon failed to make those adequate disclosures. There is another piece to all of this, and we have alluded to that in our brief, which is that Exxon may well have been attempting to obscure what the public knew about global warming through encouraging disinformation, and that would be similar to the tobacco situation. But it's also true that in the tobacco situation, they failed to disclose what they knew to consumers. They hid what they knew about the effects of smoking on lung cancer.
So just to follow up, just one last on that point. So what is the best piece in the record for us to look at about this disinformation campaign? And again, it's how it gets into Massachusetts.
There was a document authored by Exxon and a few other people having to do with a climate change plan. And it was focused around the Kyoto Accord. And it said, in essence, what we need to do is we need to sow uncertainty among people out there with respect to whether fossil fuels are contributing to global warming. And we will declare victory on this, essentially, I'm paraphrasing, when there is substantial confusion out there and basically distract the country from entering into Kyoto and other agreements.
And that document, does that get into the Massachusetts or possibly, or how do we measure whether that document somehow got here?
It was a plan that was conceived by these various entities, including Exxon, and it was, as we understand it, and this is part of what we're looking for, it was, we believe, carried out in a multifaceted way, which would have included, undertaking to change public opinion and the opinions of the motoring public throughout the country, including Massachusetts.
Well, to say the least, that an understatement, a extremely serious concern. But the whole point of the Chamber of Commerce brief is that when you have these type of situations, there needs to be some type of certainty for personal jurisdiction as to where that suit is going to be brought to address those serious allegations.
But I think, Your Honor, if you look at the cases that are cited by the Chamber of Commerce, including Bristol-Myers, I don't think that the Bristol-Myers case particularly changed in a great way jurisdiction. What it said was that, yes, there has to be a connection between the conduct and the jurisdiction. And we're not saying that the law has to be changed for us to have jurisdiction, because we think there is significant conduct by Exxon in Massachusetts. What Bristol-Myers said was, you have a situation here where there are in-state plaintiffs and out-of-state plaintiffs trying to sue a drug company over stuff that happened to them. And it's okay for the in-state plaintiffs to sue an out-of-state company because the in-state plaintiffs bought what they bought in California. It's the out-of-state plaintiffs that were the problem, because there was no connection between California and the out-of-state plaintiffs and the out-of-state defendant. Here, we're saying the situation is quite different in Massachusetts because Exxon does have connections in Massachusetts. Exxon gas is sold here, and the Attorney General stands in for the consumers in Massachusetts who would be the equivalent of the consumers in California who are allowed in Bristol-Myers to sue. So I don't think that that case in any way disrupts what we're seeking to do here in Massachusetts. In fact, if you look at the result, it vindicates our position as to the in-state plaintiffs.
All right, thank you.
Thank
We'll
you.
take our morning break.
All right.